Sure. Okay. Okay. So today's first topic is issue related to constitution. So what is the issue related to constitution? And this a few topics are there. So first topic is local reservation in private sector. Recently, Haryana government challenged the Supreme Court Haryana government passed an order. In that order, they were saying that private sector job will be allowed for the citizens of or the local of Haryana states. The same process also followed by the earlier in Maharashtra, Rajasthan, Andhra Pradesh, Karnataka, and Madhya Pradesh also. So this Haryana government uh, law passed the state legislature passed this law, and this law was challenged by a person in Supreme Court. Why? Because the 75% in quota for the private sector. So if people from other states like you and me, if we are going to Haryana for doing job, because their job opportunity is good as compared to other states, so we will not get good opportunity there because they are promoting and they were providing the reservation or the benefits to their local people. So that was a issue. And why it's more on news? Because the Haryana State Employee Local Candidates Act 2020 said that which is came into force in 15th of January 2022. In the first state in India that which is pushed to for a move that like other state like Maharashtra, as I told you, or Andhra Pradesh, Karnataka, MP, they already reserve private job for locals. So the same they are doing. Why they are doing? Because they are focusing on the soil of sun policy. Those person born in their soil, their state, they are giving benefits to them, and it's obvious. Because when we talk about the Maharashtra states, in Maharashtra, what happened that the localate of Maharashtra or the Marathi people, they hardly have a job nowadays. Gujarati or other migrants people, they are big businessmen and they are hiring those Marathi people. So that is why government of these states are promoting and providing benefits to their own people. So constitution, what is the soil of son of the soil? So in 2020 announcement by the Madhya Pradesh government to reserve all government jobs for children of the states, and which is raised questions relating to the fundamental right of equality. And this constitution provision issue a legislation of son of soil. Uh, in that, what is the now right to equality? So Article 16 said that guarantees equal treatment under the law of matter for public employment and prohibit the state from the discrimination of on the ground of place and birth. Obviously, you can't do any people discrimination on the base of their birth, the resident, their gender, and the reason. The next is Article 62, what said that no citizen shall, on the ground of only religious, race, caste, sex, descent, place of birth, and resident, for any of them for be ineligible for discrimination against the in respect of any employment or an office under the state. Upon the screen is not showing visible to me. Okay, now it's clear. So remember this. There's a five term: religious, reason, sex, caste, descent, place of birth, and residence. In any of the 5 to 6 areas, you can't discriminate people on the base of this. Now, art, under Article 16 also they said that it is it provide an exceptions by saying the parliament may make laws on that. State government don't have right to make laws that these people are not allowed to do job. State government can't say that we will providing the benefits of all only or only our citizens or our state citizens only, not on the other state people. So here parliament have a power, not a state government. So state government passed that law, Haryana government passed that law, and but under the constitution, Haryana government doesn't have a right to pass any kind of law for the private sector promotions and for the private sector job. There's some judgment passed by the Supreme Court time to time for the son of soil. So first judgment was passed in 1984 under the Pradeep Jain versus Union of India. In that, court was saying that such policies would be the unconstitutional, but did not expressively rule on its own case was in different aspects of the right to equality. But in that, they are saying that yeah, such judgment, such unconstitutional or such policy state government can do, but these policies or those policies will be unconstitutional. This will be unconstitutional and against the right to equality. In 2002, also Supreme Court invalidated that the appointment of the government teacher in the Rajasthan, which the state selection board say give preference to the applicants of which is those are belonging to that districts or that state. So at that time also Supreme Court said in that same way that this is against the right to equality. In 1995, there was a famous case. The case name is Sugandha Reddy versus State of Andhra Pradesh, and there Supreme Court struck down the judgment of struck down, that means close, and the against that earlier judgment said that a state government policy gave 5% extra weightage to candidate who had studied with the Telugu as a medium of instruction. And after that, I think now it's clear that earlier Supreme Court in 1984 in Pradeep Jain case, Supreme Court was saying that if any act or any policies made by the any state government which will be against the rights of the right to equality, but this time was government is state Supreme Court is saying that any judgment passed by the any court or any government regarding the provide the benefits of the reservation and all for the own state people, that will be allow 5% weightage given by these that states is will be normal, because in South India there is a Telugu language and other language, or the people they are did a study there, so they know that language. And other state people, if you and like in Rajasthan or in Punjab, if we will go there and do start teaching there, so it's quite difficult to us. So that is why Supreme Court gave strike down the earlier judgment. And in 2019, Allahabad High Court, which is struck down a requirement notification by the UP Subordinate Services Selection Commission, which prescribe preference for the women who are originally resident of UP alone. So say it's not only in Rajasthan or Haryana, other states also follow the same process. All states follow the soil of sun policy to protect the provide benefits of their local people or local aid people. I hope it's clear now. Pawan sir, can you please up down this? And that is why every person's requirement, birth and right is the reason. Now next is a it's not visible completely. Okay, yes. Subcategorization of other backward classes. Union Cabinet approved extension of term the Justice Rohini Commission by 6 months. This Justice Rohini Commission, which is related to the for the reservation and decide of the policy of OBC. The first Backward Classes Commission was set up by the Government of India in 1953 under the recommendation of Kaka Kalekar Committee. And in 1979, again, the second Backward Commission was set up by the BP Mandal. And this BP Mandal report is so much famous for exam perspective also, because they are talking about the reservation to provide reservation to them. Uh, for the OBC. In 1992, 27% reservation under Article 1614 provided by the Government of India for the OBC. In 1992, again, the creamy layer concept uh, was declared by the Supreme Court in the judgment of Indira Sahani judgment in 1992 for the reservation. Just what is a Justice Rohini Commission? Justice Rohini Commission. It was a constituted by the Four Constitution Commission, which is headed by the Justice G Rohini in 2017, and under the article of 340. Remember, Article 340 was set up the Rohini Commission, which this Rohini Commission was related to OBC layers, and it aimed to improve the equitability of sharing benefits among the OBC. Why? Because in OBC there is people, those are very rich and those are very poor. So that is why for the creamy lawyer concept, that those people have good enough of resources, doing good job, so they will not require any kind of reservation. But how we identify, so that is why this Justice Rohini Commission was giving guidelines and giving some structure that on that these basis criminal layer can be removed. OBC is a collective term used which is used by the Government of India to classify caste which are educationally, socially at disadvantages. OBC are referred to as a social and educational backward classes. Remember, this is a social and educational classes. Article 340 of the Constitution laid down the condition for the appointment of the commission, in which is investigate the conditions of backward classes. Now, what is the mandate of the commission? So, first of all, this commission will be examine the extent of inequitable distribution of benefits of the reservation. As I told you, that this commission set up for the provide the reservation benefits of the OBC class. Those are socially and educationally backward, and identify creamy layers also. In, for example, 27% reservation in jobs and education, and among the caste or communities, which is referred to this refer to this area. So that is why government set up these commissions. Now, what will be the mechanism? There will be focus on the criteria, what will be the norm, parameter, and also they will follow the scientific approach for the subcategorization of OBC layer, and how sub categorization in the creamy layer and the real backward classes. That is the reason. Now, OBC into four subcategories now, 1, 2, 3, and 4 split, and according to that, they are providing 27% reservation. Into that, this is the odd number, and even number 269, and they are providing the 10% reservation to them. So those people are facing or very severe condition or very poor and socially educationally backward. They will get benefit of 27%. But some of the creamy layer, but somehow they are not come under the educationally they are not good, or maybe socially they are not good. So for that, government will provide 10% reservation. I hope now it's clear. There is some committee set up by the Government of India, and Pavan sir, can you please select up? Yes, thank you. Now, what is a creamy layer? Yes, creamy layer is a two type. A household with that his income is 8 lakh and above that, and which is not eligible for the reservation. Remember that a household, if his income is more than 8 lakh, he will be not eligible for the reservation. And this creamy layer was introduced by the Sanathanam Committee in 1971. Next, Next point for the creamy layer, the other conditions for the reservation, which is led out by the Indira Sahani case. In that reservation, this is a socially and educationally backward classes. 50%, which is a cap of vertical reservation for all the categories, not for the BC or SC or ST. Total 50% reservation you can provide to the people, to provide to citizens. More than 50% is not allowed, and that is why most of the states during the elections time they increase the reservation and they provide reservation more, and that at the same time Supreme Court come into picture to struck down that decisions of the state government or to the particular government. There should be no reservation in the promotion also. If a person is appointed in a job and if he needs some promotion in his job, that time reservation will be not applicable. What is an For that, government of India to regulate or to check that is reservation is providing or not, government set up a board, National Commission for Backward Classes, and this is a statutory body which is passed by the government of India under the National Commission for Backward Classes Act 1993. Under the and for that, government of India amended this act in and that act was 10 amendment act 102 constitutional amendment act, which is mandate the constitution body as per article 338 338b of the constitution. What will be the key feature of that? So this commission will, in the case of grievances which is related to non-implementation of reservation, economic grievances, violence, etc., people will be able to move to the commissions for that, for demand of justice, and this commission will inquiry into complaint of deprivation of right to safeguards. I hope it's now clear. And there is a development of regarding to article 102. So this is a simple that this commission will check that people are get benefit or not. And recently in Ministry of Social Justice and Empowerment frame a amendment of article 342 and under the 127 constitutional amendment act, which is introduced the third clause in constitution, and the third clause is article 342a. So clause 3 said that restore the power of state to identify OBC to include the representative state list and the separate OBC list created by the government of India. Also, Article 15 of the Constitution, this is a fundamental right. Article 15.5, 16.4 expressly confirmed power on a state that identify and declare a list of socially and educationally backward classes. I hope this topic is now clear. The next these are the basics topic which is given by the book. Now basic structure. As how many of you, I don't know who know the Keshwananda Bharti. Keshwananda Bharti case is a very landmark judgment of the Supreme Court. Keshwananda Bharti, the person Shri Pallu, he was he was he put a case or he fight against justice in the for the for against the government of India during the just a wait, I'm drinking water. Wait a minute. So he's from Kerala, and recently this Keshwananda Bharti Shri Pallu, he passed away, and he was why it was in news because he was a very famous person. Keshwananda Bharti Supreme Court outlined the so I'm giving the background of this. In government of India, what they did, they because of the during the 1970 time, Parliament passed a law, and in that Parliament was saying Article 368, which is provide, which is give power to the Parliament to for the amendment of any part of the Constitution. On that, government of India was saying that Part 20 of Article 368. Now, Parliament have unlimited power to amend any of the law. The government of India was saying, and against that, and on the basis of the this law or this amendment act, now because Parliament is becoming more powerful than Constitution, as you can say, they are hiring or they are acquiring the property or land of the many states for the development purpose, and they also acquired the property or the land of the Kerala, which is on that this Keshavananda Bharati Shirapallu filed a case against on that. And in the Karnataka Keshwananda Bharati judgment, Supreme Court outlined basic structure of the constitution. In that case, the petition against the Kerala government, which is challenging the compulsory acquisition of his land by the government of India, the Kerala Land Reform Act 1963. This is the violation of fundamental right of which is Article 25, 26, and 31 of the Constitution. On that basis, in case was heard by the bench of 13 judges. Remember, this is an important judgment of India, and it was landmark judgment because Parliament how government of India do or how that government was did this. So Article 368 it gives the limited power, but because government changed this the unlimited, and government was doing acquisitions and all, and because of that there was a first case passed by the government of India. That case name is Shankari Prasad, and in that Supreme Court says that Article 368 is more power than Article 13. What is the Article 13? Article 13 saves citizens from the state for enforcement of against any of the enforcement of any of the law by the state. So this is provide the benefits or the protect the fundamental right of the citizens. So Article 368 is was given more power by this in by the by, in this Sankari Prasad case by the Supreme Court of India, and in 368 saying that Parliament have unlimited power. So directly they are giving priority to Parliament, and Supreme Court also say that ordinary law is in Article 13 is not condemned that agree 13 as an ordinary law, because this is a fundamental right and they are giving priority to Article 368, and they're saying that Article 13 is this is an ordinary law. On that, Keshwanand Bharti case passed, or Keshwanand Bharti case came into picture. The Keshwanand Bharti case in 1973, Supreme Court allow even condemn amendment also in come Article 13, because Article 13 provide justice or save people, citizens from the state. If a state pass any law against the people, uh, so the Article 13 will save to the citizens. And in Keshwan and Bharti, what government said, sorry, Supreme Court said, Supreme Court was saying that any amendment of the government of India will come and also come under the Article 13 as well. Earlier it was Article 368, but now government or Supreme Court is saying that if government pass any law or any amendment which is also against the Article 13. I hope now it's clear. As hearing proceeded, the scope of case was expanded in article because of 13 judges. This was the largest bench formed by the Supreme Court. In that hearing proceeds, the scope of the case was expanded and addressed the following interpreted in the Golaknath case. Golaknath case was the first case, then interpretation of the Article 368, which as already I told you, and the validation of 24th Constitutional Amendment Act, Section 2 and 3 of and 25th of the Constitutional Amendment Act, or 29. These were these were the cases, and these were the amendment and the Constitutional Amendment Act did by the government. On that, Supreme Court passed a reverse judgment on that. Now, what is the basic structure? Basic structure which is talk about the sovereignty of India, essential feature of India, individual freedom is secured by the citizens, mandate welfare states, rule of law, harmony and balance between fundamental rights and DPSP, and power of judicial review. So these are talking about this. Now, what is the basic structure? Basic structure, evolution of doctrine of basic structure. In 1951, Shankari Prasad case and Sajjan Singh case in 1965. These were all the case. These cases were related to the land acquisition, because government was Nehru government, which is focusing on the industrialization and development of country. That time they need some land for the setup of industry, and on because of that, so many cases were coming to picture because of the acquisition. So Parliament, in Shankari Prasad case and Sajjan Singh case, Parliament amend any part including the fundamental right, and because of this, Parliament amend many of the fundamental rights, and some of the fundamental rights like right to property was revived by the government of India under a common law. After that, in 1971, government passed government did two constitutional amendment. The first constitutional amendment article was talking about Article 13, and the second 25th constitutional amendment was talking about the DPSP and the right to property. So 24th constitutional amendment act, government constitution is not law under Article 13. Parliament can amend, because they are saying that Article 13 is not a fundamental right, and Parliament have right to amend that. In Article 25th, Article Constitution Amendment 25th say that Section 2, which is right to property, government can curtail and due compensation also. And Section 3 of this constitutional amendment was saying that to precedence of DPSP over fundamental right, that DPSP is more powerful, more superior than fundamental right, and on this basis, government of India's judgment, and you can say amendment, Supreme Court passed a judgment, and Court came into picture, and on that Keshwanand Bharti case was came, and in the Keshwanand Bharti case, line of thought maintained, and government was saying that line of thought maintained and stand in the subsequent judgment, like Mindra Mill case, also SR Bombay case, and IAS Kohilo case. These three cases after the Keshwanand Bharti are give a landmark judgment for the protect our country or protect our constitution from the state authority, as you can say. So that was the article, and the person is passed away last year. So because of that, government, because this was a landmark judgment, and that is why it's very important to us. Maybe examiner will ask this question. The next is Uniform Civil Code. Recently, Ministry of Law and Justice respond a PIL filed in 2019, and which implementations of the Uniform Civil Code. This is a matter of public policy which is not directions of regarding to be can issued by the court. UCC earlier passed was an issue was a judgment which was a misconcept, or there was a misunderstanding between the Supreme Court and between the government of India during that time, which is because of that misunderstanding which result in the rights on that time in the country. So UCC provide one law for entire country, and which is applicable for all religious community in the personal law matter also, like marriage, divorce, inheritance, and adoptions as well. So Article 14 said that Constitution lays down the state shall endeavor the secure of uniform civil code for the citizens throughout the territory of India. What is the status of uniform civil code? uniform civil code in India now. So Indian law do follow the uniform civil code in most civil matters. Like you can take example of Civil Proceeding Code and Transfer Property Act, Partnership Act, Evidence Act. 1872. But for the marriage purpose, for divorce, all the religious have a different law. You can say the Hindu Family Act, or the Muslim have their Islamic laws are different. So government of India was is focusing on, because of the, it's written in the DPSC that all the religious, all the caste have equal or same law. So and in the entire country, you can say one law for entire country, and that's the perspective of the Uniform Civil Code. And recently, several states refused to govern by the Uniform Motor Vehicle Act 2019. Uh, um, and you can take example of the one language one theory, because Hindi was focusing by the our home minister last year. He was saying that one language, one nation, one language. On that, and some of the South Indian states, they are against or refuse that statement of our home minister. So go, and the second is Goa is the only state which have the uniform civil code in the form of common family law in India. So this is an important concept. Like Goa is the only state in our country which follow the Uniform Civil Code. And background of the UCC. So pre-independent, like in colonial era, Lex Loci reports of October 1840, it stressed the importance and necessity of uniformly in the codification of Indian law, and which is relating to crime, evidence, contract. But it also recommended a personal law, like Hindu and Muslim should be kept outside such codification. In Queen's 1859 proclamation was said that it promised to absolute non-interference of religious matter. Why they were saying? Because in 1957, the main reason, or somehow the reason of the revolt uh, uh, against the Britishes was the reason of religious matter, because of the East India Company. They were so much against of religious, and that is why all the people, all the people of our country didn't face any religious discrimination for religious discrimination. That is why 1857 revolt happened, and that's how, after the realization, Queen uh, Queen's British Queen, she passed a proclamation, and she said that they will not interfere in the religious matter of India. Now, next is a B.N. Rao committee was formed to codify Hindu law in 1941. After independent or post independence, the Hindu Code Bill was passed by the government, and the bill was drafted by Dr. B.R. Ambedkar. It was a bill; it was not an act. That bill drafted by the Dr. B.R. Ambedkar to reform in Hindu law, and which is legalized divorce, opposed polygamy, and give right to inherit and daughter. But our some of the leaders, they were not favor in that law, because India that time was a you can say infant child after independence. And here so many communities, so many religious, because recently Pakistan was formed, a a new country, and in the heart and mind of people, that if a uniform code or one law for all religions will be set up in our country, that will be injustice, or Muslim people or other community, other religions, they will feel injustice because of that. So government of India didn't allow that time, and then Hindu Succession Act 1956 personal laws. There is a landmark judgment, and I will tell you in the polity class when I will take in the Shahabano case. Shahabano case is a very landmark judgment for the UCC, and after that, Sarlam Mudgal case in 1995, then Daniel Lafi case, and in the government should move toward a UCC. But government is thinking for the UCC because uniform civil code is not for benefits of people, but it's also somehow affect the religious community. And if government pass UCC, it will create a revolt in our country, which is that kind of revolt or that kind of riots happened in Shahabano after Shahabano case in 1985. So that's the reason. So Pavan sir, now it's your you can all start. Thank you, sir.
Hello students, so is my audio clear? Is it clearly
Yes,
audible
Pavan sir.
without any disturbance? Okay. So I'll discuss some more articles, some more news articles. Okay. So this first one which I'm going to discuss is about anti-conversion laws. Okay. What are these particular anti-conversion laws? What are the constitutional provisions regarding that? And why this particular thing is in news? Recently, Karnataka Legislative Assembly passed Karnataka Right to Freedom of Religion Bill. Okay, Karnataka Right to Freedom of Religion Bill in 2021, commonly called as Anti-Conversion Bill. So, what is this particular anti-conversion bill? So, suppose there is a marriage, okay, between two religions. Here we are not talking about two castes. Here we are talking about two religions. Suppose major controversy is regarding the marriage between Muslim community and Hindu community. So here two religions are there, okay, and the people they love each other and they wanted to get married. So what is happening here? Sometimes the bride or the groom, bride or the bridegroom, whoever is there, they have to convert to that particular religion. Okay, suppose a husband is there, he is from Muslim community, and a wife is there from Hindu community. So the wife from Hindu community had to convert her religion in order to get married sometimes. Okay, or the if the wife is from Muslim community, she has to convert into Hindu family, Hindu tradition, in order to get married. So in order to prevent these kind of conversions only for the sake of getting married, these states are passing anti-conversion laws. Okay, now at least 9 states, okay, 9 states have legislations on unlawful conversions. Which are these particular states? Okay, the question can be asked, which of the following states have anti-conversion laws? Okay, here the list is Odisha, Madhya Pradesh, Arunachal Pradesh, Gujarat, Himachal Pradesh, Chhattisgarh, Jharkhand, Uttarakhand and Uttar Pradesh. Okay, if you can see, Uttar Pradesh love jihad law is there, Uttarakhand, okay, Jharkhand is there, okay, Chhattisgarh is there, Himachal Pradesh, Gujarat, Arunachal Pradesh. You can see a pattern in order to remember. Okay, these states have anti-conversion bills. Okay, so first, before independence also, there are certain attempts made by the British government, okay, in order to prevent these kind of conversions. And after the independence, there are certain national laws in place, but they are failed. Okay, they could not be passed. There are bills proposed in the parliament, but they could not be passed. So what happened before independence was there was introduction of Hindu princely states in the Hindu princely states in 1930s and 1940s to preserve their religious identities. Okay, so there are princely states, right, which are under the dominion control of the British government. Those princely states, particularly Hindu princely states, are there. No, Okay, they have certain anti-conversion laws. Okay, in order to prevent conversions by Christian missionaries. Okay, so Christian missionaries came from British and other European countries, so they are converting especially marginalized communities, SCs and STs, into Christian communities. Okay, in order to prevent that, this Hindu princely states have tried. For example, Raigar State Conversion Act is there. Patna Freedom of Religion Act is there. Udaipur State Anti-Conversion Act is there. These are passed by the Hindu princely states. And at the national level, what happened in 1954, India Conversion Regulation and Registration Bill was introduced. But it is stopped at a bill stage only. It did not become an act. And in 1960s, backward communities, okay, a religious protection bill was introduced, especially backward communities. Okay, especially this particular bill is regarding conversion from Hindus to Christian communities. Okay, so in 1979, freedom of religion bill was introduced. So all these did not get parliamentary support. Did not get parliamentary support. Okay, so what is the current stand? 2015 Law Ministry said that it is matter of purely a state subject. The parliament does not have any authority to interfere in the lives of people, especially in the religious matters. Okay, because why is the reason? Because this Hindu succession act or Muslim succession, whatever religious laws are there, no, okay, they are under the state subject. Okay, so whatever marriage or divorce or whatever personal law is there, okay, that is monitored by the state governments, not the central government. That's why state governments are passing these kind of laws. So there is no national law. So parliament did not according to the constitution, it did not have the power to pass these particular laws. Anti-conversion laws can be passed only by the state governments. Okay, so what is the stance of Supreme Court here? Supreme Court also said that, okay, in Reverend Stanislas versus State of Madhya Pradesh in 1977, court upheld the constitutionality of the earliest anti-conversion status of Madhya Pradesh and Orissa. So the Madhya Pradesh state and Orissa has passed certain laws, okay, anti-conversion laws, and the court upheld their constitutionality. Court said that they are correct. Okay, here we know that according to Article 25 of the Fundamental Rights, okay, so where we have freedom to propagate the religion. Okay, I belong to particular religion. Whatever religion I belong to, I can freely process, I can freely propagate that particular religion. But that freedom to propagate that particular religion, okay, spread that particular religion to other people, that does not mean that it should be with the intent to convert another person. Okay, purposive conversion would infringe on the freedom of conscience guarantee to all citizens. Okay, I cannot force another person to convert his religion. I can say these are the tenets of my religion. Okay, these are the things that I am following. It's up to you. You can choose whatever thing. If he is interested, he may convert, but I have no authority to convert any particular person into my religion. Okay, it also held that anti-conversion acts fall within the purview of entry 1 and entry 2 of the 7th schedule. Okay, you know the 7th schedule which has 3 lists. Okay, central list is there, state list is there, concurrent list is there. The central list only central government can make law. State list state governments, and concurrent list both the central and state governments can make law. Okay, so here in the purview of state list it belongs anti-conversion acts. Okay, so in order to avoid disturbances in the public order, this public order is also under the purview of state government. That's why only state governments can pass laws, anti-conversion laws. Okay, and in Sarla Mughal case also, Supreme Court held that conversion to Islam was not valid if only done in order to practice polygamy. Okay, you know the polygamy, one particular person have multiple partners. Okay, there is polygamy and polyandry. If a husband is having many wives, it's polygamy. If a wife is having many husbands, it's polyandry. Okay, so in order to practice in Muslim community, polygamy is common. In order to practice this polygamy, if a person from Hindu community or Christian community converts into Islam only for the sake of marrying multiple people, it's unconstitutional. Okay, so anti-conversion anti-conversion laws of the states will apply in this case. In Lata Singh versus State of Uttar Pradesh, court highlighted that need for stringent punishment over acts of violence or threats in case of intercaste marriage and interfaith marriage. So what is the problem here? Okay, there is conversions. Okay, so unlawful conversions only for the sake of marriage or only for the sake of these practices such as polygamy, they are not good, and forceful conversions are also not good. Okay, we can accept them, but two two people, okay, two adults, if they are willing to marry, and if religion is interfering, okay, with their personal matters, and they want to if that person is willing to convert into that particular religion, okay, so if two people are there, they fell in love, okay, one is from Hindu community, one is from Muslim community. So the person from Hindu community wanted to take up Islam, Islamic religion, okay, and she is willing to take up that, and she converted willingly without any force. Okay, no, the community people cannot come and declare it like it is violating the religious tenets and such, that it should not say that, because they are adults, they are willingly doing that. If they are willingly doing that, okay, and if the community is showing violence, okay, or threatening them, then if intercaste marriage or interfaith marriage happened, and if the rest of the community is threatening them or doing any harm or killing them, whatever, there will be stringent punishment over that particular entire community. Okay, so if it is willingly happening, then it should be allowed. That is the stance of the Supreme Court. Okay, in M. Chandra versus M. Tangamuthu and others in 2010, Supreme Court laid down the test to prove conversion. First, there should be a conversion. Second, there should be acceptance into that particular community. Simply converting into a particular religion is not sufficient. Okay, so if I want to convert to another religion, if I want to convert to Islam, okay, so the Muslim community should accept me also. Okay, so there should be two-way process. One, I have to convert, and there should be acceptance. Then only it is a proper conversion. So finally, what we are going to say is, forceful conversions are wrong. Okay, conversions only for the sake of getting married, or only for the sake of practicing polygamy, or only for the sake of getting money in some cases, okay, that is that comes under forceful conversions. Okay, but if two adults, they are willingly in order to marry, if they are willingly wanted to convert to another religion, no one can stop that. Okay, so that is the final takeaway. So here you have to remember which of the following states have this anti-conversion bills. Okay, so and this Karnataka included, total 10 states are there. Okay, so and then you have to you have to see what happened pre-independence, and are there any national laws. Okay, and is the state government responsible or the central government responsible in order to pass these laws. Okay, and important judgments related to anti-conversion laws. All this you have to remember for prelims perspective. Okay, so the next article is about official languages. Okay, so what happened? India is having Hindu majority community, and India is having Hindi majority community. So most of the northern states talk Hindi, and southern states, if you see, okay, they are having their own language and they do not prefer Hindi as a medium of their communication. Okay, so there is a clash between the northern states and the southern states, between the central government and the state governments of the southern states. What happened was, not only southern states, the northeastern states also participated. Okay, so there is a especially with the people of Tamil Nadu, Andhra Pradesh, Telangana. Okay, so they have their language in every part of their culture. Okay, especially Dravidian languages. Okay, they are valued to such an extent that they considered their language as a mother, especially the Tamil language. So if there is a concept of one language, one nation, it will, what it will do, it will alienate this particular community. It will say that Indians should only speak Hindi. Okay, and there is enforcement of English language also. Okay, by the Britishers, that is also opposed by our people, and there should not be enforcement of Hindi, Hindi language by the central government. So what happened, in order to prevent these kind of clashes, there is a concept of official languages. Okay, so what are these particular official languages? They are mentioned in 8th schedule of the constitution. There are different schedules in the constitution, right? In the 8th schedule, whatever language is listed as an official language, okay, that particular language is having some special significance. Okay, so that, we'll see what is that. Okay, so why it is this particular official language is, it's in news since years, but now Tulu community speakers are there, no? Okay, it's a part of Dravidian language spoken in Dakshina Kannada and Udupi of Karnataka. Dakshina Kannada and Udupi of Karnataka state, and Kasargod area of Kerala. In these particular areas, Tulu community is there. Okay, they also wanted their language to have official language status. Okay, so what are the 22 official languages? It is asked many times, many times. Okay, this is a particular list. Assamese is there, Bengali is there, Gujarati, Hindi, Kannada, Kashmiri, Konkan, Malayalam, Manipuri, Marathi, Nepali. Okay, Oriya, Punjabi, Sanskrit, Sindhi, Tamil, Telugu, Urdu, Bodo, Santali, Maithili, Dogri. Okay, if you can see, just try to remember all these particular 22 languages. Okay, so the question can be asked, which of the following is a official language? Okay, or it's not an official language. The question can be asked like that. Okay, so remember. So if we see what are the constitutional provisions with regarding to official languages, one is part 17 of the constitution. It says that it deals with the official languages in the article 334, 343 to 351. Okay, article 343 to 351 of the constitution deals with official languages. And regarding 8th schedule is mentioned in article 344 clause 1 and 351 part 17 of the constitution. Okay, that's 8th schedule languages. So how to add or remove a particular language from these official languages? The power is with the parliament, and there should be a constitutional amendment, because there is an amendment of the 8th schedule. So it's a constitutional amendment, remember. Okay, but constitutional does not specify any official language of a different states. It said that Hindi can be used as an official language along with English, and the states have their own choice to take up any language as their official language. That is the stance of the constitution. Constitution did not say that Telugu people, Andhra Pradesh people should only use Telugu as official language. It's left up to the particular state. The state government can decide whatever official language they want to adopt. Okay, Article 345 of the Constitution says the legislature of any state may by law adopt any one or more languages. Okay, some states have two to three languages. Okay, for example, here in Karnataka there is Kannada language is there, Tulu language is also there. So they can adopt one or more languages in the state, or Hindi also. They can take up Hindi as a language also for all official purposes of the state. Okay, so what is the significance? What is the benefit of adding this particular language into 8th schedule language? One, it will be recognized as an official language of the nation. Okay, so it is a part of the official languages of the nation. Here the material is wrong. There is no official language of India, so it will be part of official languages of the nation. And Sahitya Academy, it is one of the prestigious academy to recognize uh, the contribution of writers. The Sahitya Academy will start recognizing the language and books that would be translated into other recognized Indian languages. For example, if a book is written in Telugu language, if the Sahitya Academy has recognized these official languages, Sahitya Academy will have the power to translate that particular Telugu version into all the official languages. Okay, and member of parliaments and member of legislative assemblies, whatever are there in the parliament, they can speak in their language. For example, Tulu is now not an official language, so the MP from the Karnataka state cannot go into the parliament and speak in Tulu language. He can speak only in Kannada language because Kannada is a official language. So whatever languages are mentioned in the official language act only, that particular language can only be used by the MPs and MLAs in order to speak. And we are writing the civil service exam, right? So we have the provision to write in our official language. So in these particular language only we can write the exam. Okay, so that is about the official languages. And then there is a new thrust for cooperative societies. So what are these particular cooperative societies? What is the importance? Okay, we'll discuss. Just 1 minute. Let me drink some water. Okay, so first we'll see some history related to it. Okay, so why this cooperative societies idea came, how this idea came, what is their significance? Okay, this cooperative societies concept especially emerged from rural areas. Okay, especially among the farming community. Okay, so there is a widespread there are certain widespread famines. There is food insecurity in the rural areas, and there is lack of credit. This is the main reason cooperative societies have found. Credit, money is not available with the farmers. Okay, they cannot buy land, they may not own land, they cannot buy whatever. After the green revolution, the new requirement for fertilizers, pesticides, okay, whatever are there, no, they cannot buy them because they do not have money. Okay, they cannot go to the bank and take loan because they do not have collateral. Okay, bank will not give loan to any person without any collateral, right? They may not have collateral. So in order to promote this particular farming community, some ideas came, okay, with to form cooperative societies in order to have credit. Okay, and the biggest cooperative, there are numerous examples of small cooperative societies. Okay, so first began in 1844 by the Britishers only. Okay, by weavers are there, no? Okay, cotton weavers are there. 28 cotton weavers formed the first cooperative. Okay, the first cooperative societies was initiated by Robert Owen in 1844. Okay, that is Rochdale Society for Equitable Pointers. This is a factual question, may not be asked by UPSC, but in the state PSCs it can be asked. Okay, so first cooperative society ever formed in India was Rochdale Society for Equitable Pioneers. The main objective of the society was to save poor people by providing goods at lower cost when compared to the market price and eliminate the middlemen and supply better services to the members. This is the first idea, first cooperative society. Okay, so biggest cooperative society ever formed in India was Anand Milk Cooperative Society in Gujarat. Okay, so what happens? Milk producers, they formed a cooperative society. Okay, milk producing farmers, and they sold their particular product on a common in a common marketing cooperative society kind of thing. Okay, so they sold in the name of Amul, and now it's famous in India, entire India. So on that particular model, many of the cooperative societies found. So whatever company you are seeing now, okay, some of the companies are foreign companies, especially from New Zealand or Australia. So most of the products are there, no, okay, they are from cooperative societies from India. Okay, that led to white revolution. So about this particular cooperative societies, why this particular thing is in news, there is a separate ministry. Ministry of Cooperation has been created by the central government. Okay, so Ministry of Cooperation. So that's why these cooperative societies are in news. So cooperative societies are voluntary associations of individuals having common needs. They are voluntary, no one is forcing them to join, who join hands to attain common academic goals and interests. It includes cooperative societies or primary agricultural credit societies or cooperative banks, whatever are there. Okay, they are voluntary associations. There was a there is no recognition for these cooperative societies, but in the 97th Constitutional Amendment Act in 2011, there was recognition provided by different articles of the Constitution. One, by introducing Article 19(1) Clause C, to make a right to form cooperative society a fundamental right. So now we have fundamental right to form cooperative society. And there is Article 343B of Part 4 of the Constitution, that is a directive principle. It states that the states shall endeavor to promote voluntary formation. The government should promote voluntary formation, autonomous functioning, democratic control, professional management. Okay, voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. That is a directive principle. They should be formed voluntarily. They should be autonomous. State should not interfere. But there should be democratic control. For example, in some cooperative society, upper caste members will dominate. Big farmers will dominate. So there should be democratic control, decentralized approach. And there should be professional management. Scientific professional management should be there. That is the directive principle. And state shall endeavor to promote such cooperative societies. And Article 99B was introduced. Part 9B was introduced. There are different parts, right? So in the Part 9B, it deals with incorporation terms of members of the board and office bearers and effective management of cooperative societies. For managing cooperative societies effectively, this part was introduced. And Part 9B extended from Article 4 343ZH to 243ZH to 243ZT. Okay, so all these particular articles deal with different aspects, such as how many members can be there in a cooperative society, how it can be managed, who are the office bearers. Okay, so this is a fact. Remember, in India, Sir Frederick Nicholson. Frederick Nicholson is known as father of the cooperative movement. Okay, so Frederick Nicholson studied the problems of the farmers after Madras famine in 1895. Said how farmers are. So after famine, it led to a new model of growth. Okay, if the farmers pool in their money, okay, they can pool in their savings, and a farmer in distress can get that particular money and he can repay the loan. Like that, agricultural credit society should be formed, and cooperative bank should be formed for farmers, for agricultural sector. So he is a pioneer, Sir Frederick Nicholson. Okay, so there are different kinds of cooperative societies. One is consumers cooperative society, producers cooperative society, cooperative credit society. Consumers, producers, cooperative credit societies, marketing, housing, farming. Okay, so manufacturers can form. Okay, so in order to provide credit, in order to provide a common market, for example, Amul is there. Housing, okay, for this residential sector, and cooperative farming societies. So how they are governed, what is the governance aspect? Cooperative societies fall in the state list. Okay, you have to remember this particular thing. State list under 7th schedule. Okay, forming cooperative society is a fundamental right, 97 constitutional amendment. Promotion of cooperative society is also a constitutional directive, DPSP Article 43B. Multi-state cooperative societies are there, no? They are under the control of central government. Okay, if a particular society is there in a particular state, it comes under that particular state government. If a cooperative society operating from different states, a big cooperative society is there, a multi-state cooperative society is there, that is governed under the Multi-State Cooperative Services Act, provides for registration of societies with operation in more than one state. It comes under the control of central government. Okay, so recently Supreme Court also annulled, okay, struck down this particular 97th constitutional amendment, particularly part 99B of the constitution. It said that 97th constitutional amendment was passed by the parliament without getting them ratified by the state legislatures. Okay, so what happened, if it is dealing with the state subject, right? Okay, without having a concurrence with the state government, state legislatures did not accept, they did not ratify. Without asking the state governments, it is passed simply. Okay, so court also said that 9B is there, that should be applicable only to the multi-state cooperative societies. State cooperative societies will be dealt by state laws only. We have said in part 9B how these particular cooperative societies will be governed, will be there, managed, will be there. No, that is applicable to the multi-state cooperative society. Remember this particular point, it can be asked. Okay, sir. So the next article is about overseas citizens of India. Okay, so this Citizenship Amendment Act, overseas citizenship, overseas citizen, NRI, all these are in news. Okay, recently what happened? Home Ministry's notification is there. Okay, that notification said that OCIs, overseas citizens of India, such as journalists are there, researchers are there, scholars are there, they have to notify about their activities. Okay, for example, a foreign citizen came, he is a journalist, a foreign journalist, he has to notify his stay, sir, to the government, that this many number of um, days or months I am going to stay. These are my activities, like that. Now, Home Ministry is saying that overseas citizens of India should also do the same. Okay, so there is a controversy. The OCIs did not accept this particular proposal. Okay, so it equates all India. It equates that Indian domiciled OCIs as foreigners. So who are these particular OCIs? We'll see. So OCIs are saying we are equated with foreigners, and NRI quota is there. Okay, if you want to study in a university, if a foreigner should come, okay, and study in Indian university, there is an NRI quota. Okay, but they are having exorbitantly high fees. Fees is very high. Okay, and there is a problem. If I want to study in USA, I can go there. Okay, and if suppose I take a passport there, it takes a lot of time. But if I took passport there, okay, what I'll do, what I'll lose, I'll lose domicile status both in India as well as that particular country. Okay, I will not be a domicile, like I will not be belonging to this particular country and that particular country also. I may be the citizen of that particular country, but acquired citizenship. That's an acquired citizenship. Okay, if OCI, this kind of provisions are there, OCI status will be diluted, right? So domicile status will be lost both in India and that particular country. That is a concern. So if we see who is an OCI, OCI is an OCI card holder under Section 7A of the Citizenship Act of 1955. Okay, so simply we can say Indian origin person but holding foreign passport. Example, I went to USA, I took US passport, now I'll become OCI card holder. Earlier I was an Indian citizen, so I have Indian origin, or either my parents have Indian origin. Okay, whatever the situation, if I am holding another passport, a foreign passport, I'll be an OCI card holder. Okay, so if we compare it with NRI, non-resident Indians, he's an Indian citizen only. An Indian citizen who is ordinarily residing outside India holds Indian passport. On a long-term visa basis, if I go to a particular country, not on tourism basis, if I have to go to that particular country and stay there, IFS officers are there, foreign service officers are there. They are having Indian passport only, but staying for a longer duration of time in another country. They are called NRIs. Okay, so what are the benefits enjoyed by this particular OCIs when compared to foreigners? They can enter India multiple times, lifelong visa will be there. Okay, they should not be registered for their length of stay. Foreigners, if they come into India, they have to get registered. So this many number of days I am staying here. Okay, financial, economic and educational fields, except in the acquisition of agricultural land. Okay, if an OCA card holder came to India and they want to acquire agricultural land, that is not there. But all rest of the things, financial status, economy or educational, in all this field, they can do whatever they want. They are in parity with NRS. Okay, so inter-country adoption. OCI has this particular provision. Foreigners cannot adopt Indian children simply. Inter-country adoption is very difficult. But Indian OCI card holders can simply adopt the Indian children, and they can become doctors or pharmacists, etc. They are on par with Indian nationals on airfare tariffs are there, no? Air travel tariffs are there, no? Money for the domestic travel. Okay, in the domestic travel, the fees is there, no? And whatever entry fees into the national parks or museums, if you go into a particular museum, there will be a board, okay, that says that Indians this much amount of money, foreigners this much amount of money. So OCI card holders are like foreigners only, right? But they have to pay the tariffs, entry fees that is similar to Indians. They are having OCI card. So those are the particular benefits enjoyed by them. As per Citizenship Act of 1955, a person registered as an OCI for 5 years. Okay, if an OCI person is there, if he want to get Indian passport, he want to become an Indian, then what is the provision? He has to wait for 5 years. He has to stay for 5 years in India. Okay, so OCI card holder, he has to stay as 5 years, and then he has to reside in India 12 months before making an application. As simple as that. At least 5 years I have to have OCI card, and at least 12 months I have to stay in India. Then I can get Indian passport simply. NRIs, already they are Indian citizens only. All the benefits available to Indian citizen they are getting. Okay, So they can become either president or prime minister. They can do whatever they want because they are Indian citizens only, staying outside India. But OCI have these particular provisions only. Okay, remember, question will be asked. Okay, so as a homework, I ask you to just go through the Lakshmikant book about citizenship. Okay, so which part of the constitution? Part 2, articles 5 to 11. How to acquire a citizenship? Okay, by birth, descent, registration, naturalization, all are there. How to lose the citizenship? Renunciation, termination, and deprivation. Okay, all these you have to read. Citizenship Amendment Act, you have to read. Okay, and it is a central subject. Citizenship is a central subject. State governments cannot make any law. Okay, the Ministry of Home Affairs periodically delegates that particular power to the states to a gazette notification. It's under the control of central government only, but state governments can make law regarding citizenship if Ministry of Home Affairs delegates that power. Okay, remember this particular point. Okay, so just go through article 5 to 11. Okay, and Citizenship Act. Okay, so and there are some other news articles. Okay, these are small articles. Just we'll go through them quickly. Okay, so first one is about Constituent Assembly. Why, sir? It is 75th year after formation of Constituent Assembly. It is formed in 1946, right? Okay, and it first met in December 9th, 1946, right? Okay, so how this Constituent Assembly has formed? By the Cabinet Mission Plan of 1946. This Constituent Assembly came into force. Okay, under the Section 8 of Indian Independence Act. Britishers, after they given independence, they allowed this formation of Constituent Assembly. Okay, so what is the composition? It has these following members. Okay, 292 members were elected through provincial legislative assemblies. Provincial governments are there, no? In the British era, also provincial governments, Madras, Bombay, okay, Bengal, these kind of provincial legislative assemblies are there, no? They have elected representatives, right? Okay, those elected representatives will elect the members of the Constituent Assembly. Okay, so 292 members are them. And then princely states are there, no? Okay, under the king's rule, different small local kings are there, Nizams of Hyderabad. Okay, so those kings are there, no? They are under the British dominion only, but they are not under the British administrative control. Okay, so those princely states have 93 members representation. Simply princely states, the king will nominate some particular person, he will be the part of Constituent Assembly. And 4 members are chief ministers, chief commissioner provinces. Okay, so chief commissioner province are there, no? Okay, in India 4 members come from. Okay, total 389 members in the Constituent Assembly. Okay, what is their mandate? To sit and write Constitution of India. What happened? Just give me a minute. But what happened later on? This partition happened. Okay, so Pakistan was a separate country. So that's why Pakistan, they found a separate Constituent Assembly. Okay, so from 389 we came down to 299. Remember this particular figure. Okay, 389 to 299. Okay, the first sitting of the Constitutional Assembly was presided over by Dr. Sachidananda Sinha. It took 2 years, 11 months, 17 days to draft a constitution for independent India. Okay, so who is the chairman of the drafting committee? Dr. B.R. Ambedkar. Okay, I ask you to read all the members of the constituent, all the members of this particular drafting committee. Okay, and then I also ask you to go through this particular historical background of the constitution, very important. Okay, so that's it about the constituent assembly. And then the reservation from for promotion in persons with disabilities are there, no? Okay, they have reservation. Okay, I if I am a person with a benchmark disability, then I have reservation. So what is that particular reservation? For entry only. I want to study in an university. I want to get a government job. At the entry level, there is a reservation. But when I get a government job, promotion is there, no? For promotion also, SC/ST candidates, OBC candidates have reservation in promotion also. So PWD candidates does not have that. So Supreme Court directed the government uh, in order to give reservation the promotion for persons with disabilities. Okay, so instructed in accordance with section 34 of the Right to Persons with Disability Act. Okay, it provided not less than 4% reservation persons with disability. Okay, in promotions. So there is a law. The central government has a law, but it did not implement it. So Supreme Court, okay, tried to implement it, asked the government to implement it. So what is according to Persons with Disability Act, a person with benchmark disability means a person is not less than 40% disability. Okay, and there should be a disability certificate. That particular person, 21 types of disabilities have been covered in this particular act. Those people are only getting disability reservation or promotion reservation or entry level reservation. Okay, there are certain cases related to that. One is Siddharaju was a state of Karnataka. Okay, it said that persons with disabilities have right to reservation in promotion as well. Supreme Court also said, okay, in 2020 judgment, there should be reservation in promotion also. Center did not implement it. National Federation of Blind case is there. Supreme Court held that computation of reservation has to be done in group A, B, C posts. A, B, C, D posts are there, no? Those posts also for there should be a reservation. In Rajiv Kumar Gupta case also, group A, group B officers are there, no? There persons with disability reservation should be there. Okay, all the government jobs now persons with disability reservation is there. Now Supreme Court is asking for a reservation in promotion also. There is a law also. There is just not implementation. Government should implement that. Okay. Next is about government aid. Okay. There are certain minority institutions, right? Okay. So educational institutions are there. Okay. Run by minorities. For example, Muslim madrasas are there, no? Christian missionary schools are there, no? Those are the minority community institutions. Okay, there is a constitutional provision under Article 30 fundamental right that state should not discriminate against any educational institution on the ground that it is under the management of a minority, whether it is a religious minority or a language minority, while giving aid. So government will provide aid to the educational institutions. We have seen government aided schools, government aided universities, government aided colleges. That aid, whatever it is, should be provided, no? Okay, government should not discriminate. The government should not say you are a minority religious institution, that's why I am not giving you aid. Like that should not be said. And Article 30 also said that constitution it is subject with there are certain reasonable restrictions also. Okay, so in order to give aid, government may specify certain terms and conditions. If that particular institution is not accepting those terms and conditions, it may not get aid. Okay, so Supreme Court said that institution does not have right to government aid. It's not a fundamental right. Question will definitely will be asked. right to government aid is a fundamental right under Article 30. Is the statement correct? Wrong. It's a part of fundamental right saying that state should not discriminate. If state is providing this particular aid, giving this particular aid, it should not discriminate, saying that you are a minority educational institution, that way I'll not give aid. If it is not giving any aid at all, the institutions cannot say that we have fundamental right to receive aid, so we have to get aid. The institution should not say that. Okay, remember that. And then the sedition is news, hate speech is news. Okay, so and then we'll discuss about sacrilege and preventive detention. So sedition, hate speech, these terms are like very similar to each other, right? Okay, so section 124A of the IPC, Indian Penal Code, section 124A, this is the section, remember this name. Okay, it deals with sedition. What is a sedition? Sedition is an offense committed when a person brings or attempts to bring hatred or contempt or attempts to excite disaffection towards government. Okay, if I am doing something anti-government, if I am saying government should be brought down, government is illegitimate, that comes under sedition. Okay, so no one should question the authority of the government, right? There can be questioning of government's policies or acts, but it should not question the government itself. For example, Naxalites are there, they want to overthrow the government, that is an act of sedition, either through words or signs or any form of visible representation. If I am bringing sedition, it's a non-bailable offense. I can be arrested, no bail will be given. Person will be given for life imprisonment or imprisonment up to 3 years with fine. But what is happening, this sedition law was misused by the government many times for small things also, for criticizing the government for their policies. The government is implementing sedition law. So Supreme Court said that in Romesh Thapar case, in Kedarnath Singh case, in Kanhaiya Kumar case. Okay, so Supreme Court said that whatever sedition is there, if a sedition is done, it should disrupt the public order, it should attempt violently to overthrow the lawful government, or it should threaten the security of the state. In those cases only, you have to use the sedition law. In simple cases, you should not use this law. Okay, that is about sedition. Hate speech. Home Ministry constituted a panel to suggest the offences related to speech and expression. So there is no clear definition of this particular hate speech in the Indian Penal Code. So there is a committee for reforms on criminal laws. Okay, so it is attempting to define this particular hate speech. Okay, that's why it is in news. So there are certain definitions. Okay, Bureau of Police Research and Development said that hate speech is a language that denigrates or insults or threaten or target an individual based on their identity, such as sexual orientation or disability or religion. Okay, hate speech. For example, if I said that Hindu community or Muslim community are this and this, that kind of religious remarks, if I do, then it comes under hate speech. Okay, so there are certain laws related to hate speech, but there is no clear-cut definition in the IPC. So there is a panel, there is a committee that is reviewing, that is giving a definition. You have to wait for that. Okay, so section restrictions are imposed under Article 19, Clause 2. You know that we have reasonable restrictions on the freedom of speech and expression if it is threatening national security like that. Okay, and section 124A, sedition, is there. 153A and 153B are there. That punishes the act caused enmity or between, if I bring enmity between two groups, section 153A and B are there. Section 505, 1 and 2 of IPC. It penalizes publication or circulation of any statements in newspaper or social media, whatever are there, no? Okay, in order to bring enmity or hatred or ill will between two classes, if I publish anything, if I write anything that deals under section 505 1 and 2. The Law Commission in its 267th report also said that, okay, incitement to hatred primarily against the group of persons defined as a term in the race or ethnicity or gender or sexual orientation or religious belief. Okay, in whatever the situation, if a person is inciting hatred, then it will be under hate speech. Okay, whereas committees also recommended in order to introduce this particular thing into hate speech. One is Vishwanathan committee and okay, uh, Besbarua committee are there. 2019 proposed section 153C. A and B are there. New section C and 505A. 505 1 and 2 are there. 505A in order to be introduced for hate speech. Okay, it also said that this Bejrao committee also said that section 153C new section should be incorporated. Okay, to deal with hate speech cases, and 509A also. Okay, 5 years punishment and fine also given, and here 3 years punishment and fine is given by this particular committees. Okay, and next is about sacrilege. Okay, so what is this particular sacrilege? Punjab government has written to the center for assent to the state bill that proposes life imprisonment for the desecration of religious scripture. Okay, you know that religious scriptures or religious idols or religious places or religious things, whatever are there, they have certain inherent value. All the people of belonging a particular community, they pray to that particular religious thing. Okay, so another person belong to the same religion or another religion, they should not uh, say derogatory words. They should not do derogatory actions that reduces the sacredness of that particular thing. Particularly Sikh community, okay, it has a particular religious tenets to be followed. Okay, if anyone is violating, it comes under sacrilege. It comes under blasphemy. Okay, so there are a certain section 295A, 295 and 295A, 296, 297, 298 of IPC that deals with the blasphemy. Okay, so intentional damage or destroys or defiles any religious object, that comes under section 295, and 295A deals with malicious words spoken or written, or signs or visible representation that attempts to insult any religious sentiment. Okay, so you have to remember in this what is a sacrilege, what is blasphemy, okay, and what are the sections dealing with that. Preventive detention is there. Okay, in this Bankas Neha Selvas in the state of Telangana case, Supreme Court ruled that provision for preventive detention cannot be invoked over apprehension of law and order problems. Okay, simple law and order problems of the state. Okay, there should not be sedation, preventive detention. Okay, so what is this particular preventive detention? I am there. Okay, I did not commit any particular crime, but I was detained to uh, in order to prevent that crime from happening. Okay, I have anti-national thoughts, suppose. Okay, and I have publicly said that I will do certain public nuisance, a public law and order situation or public threat, I can say. Okay, then I will be under preventive detention. I did not commit that particular crime, but in order to prevent me from committing that, I will be arrested and detained. Okay, so there are certain rights, fundamental rights given to the citizens. Okay, there is right to protection against arrest and detention. Okay, and those rights said that I should have knowledge on the grounds of my arrest, why I have been arrested. I I have right to consult a lawyer. Okay, they're defended by a legal practitioner. So all these rights are not given in the case of preventive detention. You have to remember that. Okay, then a right to protest and right to be forgotten are there. Okay, so from here we'll continue tomorrow. Okay, so that's it for today. If you are having any doubts, you can ask me, or else we can end the class here.